Good afternoon, everyone. My name is Madhusudan Sarma, and I welcome you all to this lecture of N100 series. In this series, we are covering complete polity from mains perspective. And today's topic for discussion is judiciary. In today's class, we are going to cover the issues and debate related to appointment of judges. We are also going to cover the issues of pendency of cases in judiciary, and then the issue of regional benches and PIL. These shall also be discussed, and in tomorrow's class also we are going to cover some aspect related to judiciary like lok adalat, alternate dispute redressal, etc. So let's start the class. And the first and foremost thing that we are going to discuss, see, some aspect of judiciary we have already discussed. Like in the last class also we have seen how separation of power mandates that judiciary be independent of other two organs of the state. So there are three organs. One is legislature, we have already covered that. The second organ we are dealing is judiciary, and after that we shall also be discussing with executive organ. Okay. Now, traditionally, after independence, as we have discussed yesterday also, like the executive was appointing the judges, and this was the mechanism of checks and balances between three organs of the state. So, judges were appointed by president. But this process came to be misused by the government, because the government had to implement, the issue started with the land reforms acts. The government had to implement its social justice agenda, and to implement the land reforms, judiciary was entitled with the duty of protecting the fundamental rights, and here both judiciary and executive were coming at loggerheads. So to implement the land reforms, the government had to compromise with the right to equality, to right to freedom, and at that point of time, right to property was also a fundamental right, and judiciary was very often protecting the fundamental rights. In this process, the idea at that point of time was given of committed judiciary. This is also something that we have covered in earlier lectures. So, like by the time we move to the last half of our lectures, a lot of concepts that we have discussed in the first half will be revised as well. I would expect you to give prompt answer to those questions which we have discussed in the earlier classes. In case you have missed the earlier classes, you can go to the Narayana IAS Academy YouTube channel and watch the playlist N100 series. Okay. So committed judiciary, I will tell you again. Committed judiciary means, this was the idea that the judiciary committed to the policies of the government. Okay, so judiciary was expected not to act as an obstruction in the implementation of policies of the government. What was the rationale behind this? The rationale was that the government has got the mandate from the people, and in the democracy, the people are paramount, people are supreme, and since government has got the mandate, so that's why its policies should be implemented by the judiciary. Judiciary should help in implementation of these policies. Good afternoon, Yogesh and Manoj. So when judiciary was not doing it, the idea came that there are few judges who would be willing to implement the government policies. Why not appoint those people in judiciary only who are committed to the policies of the government? And from here, this misuse of this appointment process started. I am going to give you a few examples of misuse, but these were not the only instances of misuse. Okay, the instances were also, like, I will give you the example which can be objectively proven to be a misuse. For example, the principle of appointment of CJI was that the one who is the senior most judges among in the Supreme Court, who would, that person would be appointed as Chief Justice of India. But if someone who is senior most is not appointed CJI, we call it as a misuse of this process. But when the transfer was also used, the transfer of high court judges was also used as a tool for penalizing those judges who were giving judgments against the wishes of the government. Okay, so few examples that you should write, because this is the example which we can quote objectively. Like from 1950 to 1973, there was the convention to appoint senior most judges as the Chief Justice of India. But in 1973, this convention was broken when A.N. Ray was appointed CJI, superseding three other judges. Okay. Later on, again in 1977, Justice M.H. Beg was appointed, superseding Justice H.R. Khanna. And as we have discussed earlier also, H.R. Khanna had played a very key role in Kesavananda Bharati judgment also. And later on in ADM Jabalpur case also, H.R. Khanna was the one who had given the dissenting judgment that the fundamental right or right to life of the people cannot be suspended even during emergency. But the majority opinion was that the right to life or any fundamental right can be suspended during emergency. Okay, so obviously the government has got the idea that this is the person who is going to protect the liberty of the people. So this person should not be made the Chief Justice of India. Okay, so these are the instances which you can quote that there was misuse. Obviously, Supreme Court was worried. The legal fraternity was also worried, and it was being there was this feeling that government has hijacked the judiciary. In fact, it is written even in the NCRT. You can read it that when during emergency, judiciary was asked to bow down, it started crawling. Okay, it was just asked to bend, then it rather decided to crawl. So judiciary was being accused that it had lost its autonomy. On this ground, few people approached the Supreme Court saying that this appointment being done by government is not right, because when the government is doing the appointment, it is impacting the autonomy of the judiciary. The independence of the judiciary is compromised when appointment is being done by the government. So this is the article 124. This article says that the judges of the Supreme Court, and the similar article we have for the High Courts also, the judges of the Supreme Court will be appointed by President under his hand and seal. I have omitted those terms. Just focusing on the things that we have to understand. They shall be appointed by President after consultation with such of the judges. Here the key word is consultation. Consultation with such of the judges of the Supreme Court and of the High Court in the states as the President may deem necessary for the purpose. Okay, so in the few people argued in the court that, see, if we have to maintain the independence of judiciary, this consultation should be binding. The consultation should equal to concurrence. Concurrence means whatever be the suggestion or recommendation given by the CJI or judges of the Supreme Court, that should be binding on the president. But in the first judge's case in 1981, the Supreme Court said that no, the consultation does not mean concurrence. Consultation is just consultation. The president has his autonomy. He can decide on his own. He can go against the recommendation of the Chief Justice of India or the other Supreme Court and High Court judges. But in second judge's case in 1993, the Supreme Court changed its stance. The Supreme Court said that consultation means concurrence. Why? Because if there is no concurrence, in that case, the autonomy or independence of judiciary is compromised. So to ensure the independence of judiciary, it is necessary that the opinion of CJI should get primacy. Okay. Then CJI will, it was also said that CJI will not give his personal opinion. Whatever the suggestion given by CJI should be the suggestion of after consulting two senior most judges of the Supreme Court. This should be the basis of consultation. It should not be the sole opinion of CJI. From here, the collegium system took birth. And this group of CJI and two senior most judges, this group was known as collegium, and this collegium will give the advice to the president as to who should be appointed as the judges of the Supreme Court. Okay. After that, obviously government was not happy with this, so government again went into appeal against this judgment. Then in third judge's case, Supreme Court still maintained this stand that consultation would mean concurrence, but the Supreme Court revised the composition of collegium, and this is the current status that you should remember. This, it says that CJI should consult four senior most judges of the Supreme Court. So the collegium will consist of 5 judges, 1 CJI and 4 other senior most judges. And it, in case there is an appointment of High Court judges, the collegium will consist of CJI and 2 senior most judges. Okay, and obviously in case of appointment of judges to High Court, there should be a High Court collegium as well. And this High Court collegium shall consist of Chief Justice of High Court and 2 senior most judges of the concerned High Court. So, this High Court collegium will give recommendation to the Supreme Court collegium, and this Supreme Court collegium will then give recommendation to the President, and President will appoint the High Court judges. And when a High Court judge is to be promoted to the Supreme Court, in that case, there would be a collegium of CJI and 4 senior most judges. This collegium will give recommendation to the President, and then President will appoint such and such person. It was also said that President can ask for reconsideration once. So, President can say that, okay, please reconsider this name. If the government is not happy with any of the names, it thinks that it is not appropriate, he can ask it for reconsideration. But if the collegium reiterates the same name, then the President has to appoint that person. Well, again, there is no timeline prescribed here also. So, President can take its own time in appointing or rejecting the name of judges. And this is something that this government has been doing. Like some people who have given judgments against the government has been holding on their names. The government cannot reject it. Government cannot violate this judgment, but the judgment does not give the name. So, if suppose 3 people are recommended as the Supreme Court judges, the government will appoint 2. The government will hold on the 2 names. Then after 6 months, government will send the name back to the collegium. The collegium will reiterate it in 1 month's time. Then again, the government will hold it for 4 months or so. Okay, so in this process, there is a delay in appointment of that person for approximately 1 year, 1.5 years or so, and this delay makes sure that the person will not become the CJI. Had he been appointed first, in the very first instance, he could have become CJI. So these are the small nitty-gritties that is happening, and you can notice these things if you follow newspaper on regular basis. If you follow the newspaper trail, and maybe you never know, sometimes this understanding can help you in writing 1 or 2 additional points in the answer. Next is the government in 2014, 99th Constitutional Amendment Act was brought, and also there was a NJAC Act. This installed an body named as National Judicial Appointment Commission, and this body was given the task of appointing the judges to the higher judiciary, that is High Court and Supreme Court. The composition of this NJSC was that there should be Chief Justice of India, plus there should be Law Minister, plus there should be 2 Supreme Court judges, and then there should be 2 eminent jurists. So there was the 6-member body NJSC, 1 CJI plus 2 Supreme Court judges, then law minister, and 2 eminent jurists. And to appoint these 2 eminent jurists, there was this committee of CJI plus leader of opposition plus, sorry, first I should write prime minister. So prime minister plus CJI plus leader of opposition, these 3-member committee, this committee will appoint these 2 eminent jurists, and then these 6 people will appoint the judges to the higher judiciary. This was the proposal of NJSA. So this was in tune with the philosophy of our constitution, in tune with the checks and balances which our constitution has originally prescribed. And as such, it was a good mechanism, because see, it was having the primacy of the Supreme Court judges, primacy of judiciary, because 3 members were directly from the judiciary, and then it was also having a membership presentation from the executive in the form of law minister. Apart from that, there were outside members also who were neither member of judiciary nor member of executive. So probably they could have been eminent jurists, could be some experts in law, maybe some prominent advocates could have been the member, or maybe some legal luminary professors, etc., could have been the people. Okay. In case of eminent jurist, the word eminent person was used. Make this correction. Eminent person. This was the word that was used. Okay, but then in 4th judge's case, in 2015, Supreme Court declared this amendment as null and void. This is the only amendment, as we have also studied in the chapter of basic structure. This is the only amendment that has been declared null and void on the ground of violating the basic structure of Constitution. The Supreme Court said that the independence of judiciary is part of basic structure, and as soon as there is a role of executive in appointment process, the independence of judiciary is violated, is compromised. And so that's why this amendment was declared invalid in its entirety. It's not that some provision, some article was declared invalid. Complete amendment was declared null and void. So even if you download the say constitution from the Ministry of Law and Justice website, you can still see that there is Article 124A, Article 124B, Article 124C. These articles are still there which talk about these amendments. But in the footnote, you can see that these amendments have been declared null and void on the ground of violation of basic structure. If you have any doubt till now, please let me know. This is an evergreen topic. It never becomes old. The collegium system is. We are also going to discuss the pros and cons of collegium system. Okay. So these are these judged cases. They are important for prelims as well as mains, and they are evergreen. A question can be asked on them anytime. So if it is clear, please confirm. All clear, sir? Are you still there, or all of you have went to sleep? In afternoon, studying is very difficult, isn't it? So this is the time when we must feel sleepy as well. But you know, the success comes when you start doing things when things are going tough. Like when it is interesting, everyone will do it. When it gets boring, when you are feeling sleepy, when it is afternoon, at that point of time also, if you are studying, if you are working in the direction of your goal, this is the time when you start getting success. Yeah, especially after lunch. So this is what I do. I drink a cup of coffee after the lunch to remain fresh during the class. You can also try the same. Take tea or coffee, whatever be your choice. Do not eat too much of sugar. That is not good for the students. Okay, chalo. Let's move to the next point, that is about declared NJSC null and void, reinstated collegium system. So still our appointment of judges is happening as per third judges case 1998. Okay. Next is what what are the criticism of collegium system. So what is the good with collegium system? The good point is that collegium system has installed independence of judiciary. The misuse of appointment process has stopped. The judiciary, its autonomy is reinstated. That is the sole purpose of collegium system. Okay. Now we are going to study what are the criticism. Sir, the decision of collegium is decided by majority of judges or concurrence of all 5 judges. No, in this case what happens I will tell you. CJI plus 4 judges are there. Now the first thing is that if CJI does not agree to any one judge, any one name, that name shall not be recommended. So there is primacy of CJI. There is first thing. Even if like all 4 judges are saying that Mr. Madhusudan will make the next judge of Supreme Court, but CJI is not agreeable, Mr. Madhusudan's name will not be recommended. That is the first thing. Second thing is that obviously after that there has to be majority, like 3 is to 2. So 2 judges can go against someone's name, but if 2 judges who are going against someone's name, out of these 2 judges one should not be CJI. So CJI and 2 judges, if you are agreeing on any particular name, that name can be recommended. So it's not the consensus, that's definitely not the issue, but CJI must be agreeable. That is the point. That is how names are recommended. Next is the criticism of judiciary is that criticism of this collegium system is that it is against the principle of checks and balances. We have seen the checks and balances required that executive should also check the judiciary, and this was done through appointment of judges by president, but that power of president is being taken away through this collegium system. So now that checks and balances has stopped. Next is, so no role of executive. Next is this process of appointment, the way collegium works. This is marred with secrecy. Like even minutes of meeting, the minutes of meeting of collegium is not disclosed. Not only the minutes of the meetings are not disclosed, even collegium did not disclose the reason for selecting someone or rejecting someone. The collegium just mentions that these are the names which are recommended. Why someone is recommended and why someone is not recommended, that is never disclosed. So there is no transparency in the standards being followed. No defined criteria for testing the candidate. We do not know as of now today what is the criteria on which collegium takes a decision. There are guesses, like the way we make the guesses for UPSC, that how probably if you write the introduction, body, conclusion, you get more marks. But for certainty, we do not know that if this format, introduction, body, conclusion, if writing in point format is beneficial, if giving example, data, etc. is rewarded or not, we do not know. We are just making a guess. Similarly, for collegium also, we have a guess that probably these are the criteria used. For surety, it is never declared. We do not know that what were the criteria used for one particular judges. And in the absence of any defined criteria, in the absence of any minutes of the meeting, obviously there are accusation. Accusation is that there is favoritism and nepotism. In Hindi, bhai bhatijabad. Okay, and like there is a terminologies, like there is uncle judges syndrome, and this is something, this is very well written in all the newspaper, etc. You can write it, but you have to be very careful with the wordings. You have to use the word accusation of favoritism and nepotism. Do not say that there is nepotism and favoritism. CGI Chandrachud was made the judge because his father was CGI. Never, never write in such a language. Always write that there is accusation. Few people are saying, and this accusation has been made by none less than the law minister itself. Law minister has made such a statement, and lot of government functionaries have made time and again such a statement. Okay, and this is called uncle judges syndrome. Uncle judges syndrome means you are going to be judged because your one of the uncle is also a judge. Okay, in fact, when this NJSC judgment was, the Supreme Court was dealing in the fourth judge's case, deciding on whether NJSA is constitutional or not. A survey was done, which was published in Hindustan Times, and this, or which was also submitted to the bench in the Supreme Court, and which says that 50% of judges in High Court and approximately 33% of judges in Supreme Court, 50%, 33%, relatively easy number to remember, are family members of, these many judges are family members of those in higher echelons of judiciary. Higher echelons of judiciary means like those people who are famous judges or famous advocates. Like if you are already High Court judge, if you are already Supreme Court judge, or if you are a senior advocate in Supreme Court. So these are the people who are considered as those who are in higher echelons of judiciary. So half of the judges, you can say, in High Courts, all the High Courts put together, and 1/3 of the judges in Supreme Court are those whose family members, like current CGI, you can say that his father was also CGI. So they are related to the same family. Or like this is also a statement which was given by Ravi Shankar Prasad once, that there are around 200 and 250 families who are giving judges to the Indian judiciary. I do not know if that is correct or not, but obviously this is a fact that there are only few families. If it is 200 or it is 1000, I do not know, but obviously it is true that there are few families who are giving judges. Obviously there are few families who are giving heroes in our Bollywood, etc. also. Okay, so people are saying that on the same line, like only Kapoors are becoming heroes in Bollywood industry, and so only few families are giving judges in higher judiciary. And people are saying that it is happening because judges are appointing judges. Why? Because in collegium system, what is happening? Judges are appointing judges. People are saying that had there been a merit system, the way IAS are recruited, there is open recruitment. So very, you can see few examples where the son or daughter of IAS is becoming IAS, but this is not ubiquitous. It's not that all the IAS officers, or like 50% of the IAS officers are those whose fathers or uncles were also IAS. But in judiciary, it is happening. So people are saying that it is because of this collegium system. Okay. And then there is another problem, that there is no official secretariat of collegium either. So had there been an official secretariat of collegium, there would be continuity. There would be bureaucracy who would maintain the records, minutes of the meeting would be circulated. Nothing such of that kind is happening. Okay, and then the outcome is another question on collegium, that there is underrepresentation of various sections, also scheduled caste, scheduled tribe, and women. Like there has never been a woman CGI. In 2027, India is going to get the first woman Chief Justice. In fact, only 4% of all Supreme Court judges have been women. See, here the situation is even grimmer than the one in Parliament. In Parliament, at least 40% of the judges are, 40% of parliamentarians are women. Here, the matter is only 4% cumulatively if you look at all the judges that have been there. And the first time in 2027, Justice Nagaratna, she is going to be the first Chief Justice of India, woman Chief Justice of India. Okay, VV Nagaratna. Yesterday, only one judgment has come where she has given a dissenting judgment. Have you read the newspaper? This judgment of the Supreme Court that has come regarding the industrial alcohol taxation power or regulation power of the states with respect to industrial alcohol. Have you read it? Please confirm. Missed it? No, no, do not miss the newspaper. And see, in newspaper, one thing is certain. In polity, Supreme Court, any word uttered by any judges of the Supreme Court and especially Chief Justice of India is a golden word for us. And in economy, anything said by RBI, not Finance Minister. RBI is the most important pillar in economy and CGI is the most important pillar in polity. So definitely read newspaper and all the statements given by CGI, especially with respect to any constitutional interpretation. I will very briefly. I will give you the detail of the that interpretation of the Supreme Court. Supreme Court has said that normally you must be aware that alcohol is taxed by the government, so that's why alcohol is out of by the state government, and that's why alcohol is out of GST also. This is the major source of revenue for the states. Okay, and here is there is something very interesting. Normally we know that excise duty is the domain of the central government. Central government have a like in IRS there is also one division of IRS IT, one division in IRS custom and excise. So you must have idea that excise duty is levied by the central government. But then on alcohol, the power to levy excise duty is with the state government also. A state government levy something known as additional excise duty. Okay, because there is entry 8 in the state list that mentions that anything related to production, uh, distribution and sale of intoxicant alcohol would be the domain of a state government. So Supreme Court has in studies judgment interpreted that the complete power with respect to regulation of even industrial alcohol, like obviously the alcohol that we are drinking for enjoyment purposes to say cheers, is part of a state government domain, but even industrial alcohol is the domain of state government. Normally, industries are in the domain of central government. So that's why since industries are the domain of central government collects the excise duty in the form of SENVAT. But since alcohol is completely in the domain of a state government, so excise duty on alcohol is collected by a state government. Okay, more detail you can study in the newspaper. All the newspapers have covered it, whether Indian Express or Hindu. Next is what are going to be our suggestions. If alcohol comes under GST, the officer works for Excise Department of State. What happens with them? See, GST is collected by both center and a state, na? So those officer will also collect the state GST. Currently also this is what happens, that the sales tax which earlier the officers in the state government were collecting, Now those officers are collecting a state GST. So they will collect a state GST in a state GST from the alcohol shops also. But probably what you are referring to is what will happen to their additional income that they demand illegally over the table or under the table. Definitely there would be loss in that, and with the loss of income there would be loss of prestige also. Those services would no more remain so much sought after. Okay, so what is the way forward? What is our suggestion? See, suggestion for looking at the suggestion, probably we can look at the system that are there in the other countries. If you look at the system that is there in UK or the system that is there in South Africa, everywhere you see that there is a commission kind of system. There is a appointment commission, judicial commission or something like that. For example, in England there is a judicial appointment commission. This Judicial Appointment Commission has 15 members, and these members are from Judiciary, these members are from Executive, and there are members among the legal fraternity, there are members which are outside the legal fraternity also. So it has very diverse representation. What I mean, exactly, we are not appearing for the United Kingdom Civil Services. So what we have to simply say that in UK also there is Judicial Appointment Commission, and this commission has representation from Judiciary, obviously majority of the people, or rather not majority, around out of 15 there are 6 which are the judicial members. So even it does not have majority from Judiciary, but it has representation from Executive, it has representation from among advocates, lawyers, it has representation from Judiciary and other sector also. And this diverse representation is doing the appointment of judges. In South Africa also we have the same thing. There it is called Judicial Service Commission. This Judicial Service Commission, it also have like law minister, it also have some judges, it also have their chief justice, and their attorney general is also there. So the idea is that other countries also have similar mechanism which was there in place for NJSC. So a lot many legal people still agree that probably NJSC was a better system than the collegium system. However, one more thing that you can give an argument is that we should have something like National Judicial Commission, which was recommended by National Commission to review the working of Constitution, and this has CJI plus 2 Supreme Court judges plus law minister plus one person nominated by president. This was the composition which was recommended by NCRWC. Okay, so obviously since it was a 5-member commission and with CJI and 2 Supreme Court judges, there was majority of judiciary in this, whereas the NJSC that we had brought and which was brought by 99th constitutional amendment, that NJSC had only 3 judges out of the 6 members. So it did not have the majority of judges. So maybe this could be another mechanism for bringing about for appointment of judges. Apart from that, you have to write this. Let's see, we need to balance the independence and accountability. I mean, what currently happening is that we are giving too much emphasis on independence only. What about accountability? So probably a balance has to be brought about. And then even if we are continuing with the current provision till the time we are continuing, there should be mechanism to ensure transparency and objectivity. We can always identify, see, for appointment of civil servant, UPSC has come up with various criteria that there shall be an interview. An interview will have weightage of 275 marks, and how many marks one candidate get is declared. So maybe a similar procedure can be evolved. A objective ranking criteria something can be given, okay, for clear and objective criteria could be given for the selection. Okay, and then there should be some mechanism for recording and publishing the decisions of the collegium. It should not happen that only names are being given public. See, however, you must also be aware the rationale given by judiciary. See, these are the judges, so they must have given some logic why they are not declaring the reason. They are saying that, see, suppose we are considering a name of any high court judge for elevation to Supreme Court, and in this process his name is considered and we find that he is not currently suitable to be elevated to a Supreme Court. Or it will always happen that we shall consider say 5 names, and then out of those 5 names we will recommend 2 names. Okay, so if we have any adverse opinion about any high court judge, and if it is made public that is because of these reasons someone is rejected, the public confidence in that judge will go down, but that person will still act the judge of the high court. So all his judgments given as the judge of the high court would be questioned, and they people will lose trust in high courts. So that's the reason why we cannot make the observations of collegium public. So that's why we are saying that we should not have this subjective opinion of collegium should not be made public, but we should derive certain objective criteria. Like, see, there could be criteria that how many of judgment given by a particular judge has been overturned by the Supreme Court. So this can be a very good criteria. Like if a lot many judgments are being overturned, then this is definitely a matter fit for like the judge is not fit for elevation. And how many times constitutional interpretation has been done by a judge, and that has been verified or rather approved by the Supreme Court. So such criteria can be used. We can definitely come up with those kind of criteria that will be helpful in addressing the accusation of lack of transparency or favoritism and nepotism. Do you have any doubt? And the last suggestion that is often given, that there should be affirmative action in judiciary also. Why should only have reservation in executive? In legislature also we have the mechanism of affirmative action for scheduled caste people and for women now. So in the third organ of the state, that is judiciary, also we should have affirmative action which will promote diversity. Okay, so we are having all this debate about the collegium system, and the whole debate is about the need to maintain the independence of judiciary. Then the question that can also be asked is that why do we need the independent judiciary? What is the need for independence judiciary? And this is something that you must be knowing. There is nothing new, but see, such basic questions can also be asked sometimes. So we should have 5-6 points at hand, at ready immediately, that as soon as the question comes, within 2 minutes we should be able to write those 5-6 points. So please tell me in the comment section, in the chat, why do we need an independent judiciary? The issue is not that you know it or not, you know it, I know. The issue is how quickly you can write 5 points. So please mention. Let's see how many points can you give me. Why do we need independent judiciary? We have studied a few points as well. In fact, I am hardly going to tell any points which we have not studied. To avoid arbitrary action of government. Okay, we see, probably what you are trying to say is that government is the biggest litigant in the court. So, in case the judiciary is not independent, the rule of law would be violated, or other principle of natural justice would be violated. Government, if the judiciary is favored or rather compromised or tilted towards the government, then effectively government is going to judge its own case. This is going to be violative of principle of natural justice. Yes, judges should be able to perform their duty without any fear or favor. Yes, that's right. Or any influence. Okay, so a few terms. Uh, am I audible? Just confirm if. Okay. So the first point is, separation of powers, because independence of judiciary is required because there is separation of power, and there is also because there is need for checks and balances. Checks and balance will happen only if there is independent judiciary. So separation of power will also be ensured if there is independent judiciary. Checks and balances can also be ensured because there is independent judiciary. And why do we have separation of power? So that there is constitutionalism, so that the rights of people are protected, and judiciary has the duty to uphold the constitution. Who is going to attack the constitution or who is going to compromise the constitution? It is the other organ like legislature and executive. So obviously judiciary should be independent of legislature and executive if it has to uphold the constitution. And then independence judiciary is the core feature, one of the core feature of federalism. This is the point which is very often missed by the students, that federalism, to ensure the spirit of federalism also, there is a need for independent judiciary. Okay. Then since there is a mechanism of judicial review through which we ensure the accountability of the government, this accountability can only be ensured, judicial review can only be effective. The point that you were saying, that government is the biggest litigant in the court. All the important cases that we study, it is like versus the state of Rajasthan versus the state of Union of India. So one of the party is always government. Always, not always, but mostly government. Government is the biggest litigant in the court. And in case government, government has any influence in judiciary, effectively there is violation of principle of natural justice. Government is becoming a judge in its own case. And then protection of individual right, because rights are being violated by who? Government. Rights are negative obligation mostly against the government, a state. So if a state is violating the rights, there has to be someone independent of the government to protect the rights. The violator cannot be protected. No? I mean, lion cannot protect the, what do you say, Mames in the forest. Next is minority protection. This is like same line, one of the individual rights is minority rights. But if minority has to be protected, the judiciary has to be independent. So these are the points that you have to write. And also to maintain the confidence, there is also a quotation that you must have studied, that justice should not only be done, it should seem to be done as well. Okay. So people should have faith in the confidence in judiciary, and for that also it is important that there is independence of judiciary. And there is another quotation also, that the Caesar's wife must be beyond suspicion. Julius Caesar, this is a dialogue from Julius Caesar, that because Caesar's wife, Caesar is king, so the king's wife we should be beyond suspicion. So similarly, judiciary should be beyond suspicion that it could be compromised. Like see in the case of Ayodhya verdict, this is the accusation which is being made by the Dane CGI. A lot many people are making this accusation that probably the CGI should not have taken the post of or rather nomination as member of Rajya Sabha, because when he accepted the nomination of Rajya Sabha, irrespective of the merit of the judgment, people have a reason to believe that probably there was a quid pro quo between the government and the CGI, the then CGI. Okay, we do not know the merit, but definitely there is a iota of doubt, and even that iota of doubt should not be there. Okay, and you have to be very careful while writing the answers. Okay, you should not simply say that this is like CGI was biased or something like that, but definitely people are able to point fingers because of those acts. And then rule of law, the rule of law also demands, as you have rightly said, that there should not be any arbitrary action. An arbitrary action would be possible if the independence of judiciary is compromised. Then independent judiciary, see there is a lot many times when government is one of the litigant with respect to businesses, with respect to the companies who are coming as FDI. So an independent judiciary would be able to enforce contracts effectively. All the parties will have faith in judiciary, and this will also lead to business development. So there is an economic angle also. Economically also we would be better off if the independence of judiciary. This is another point which most of the students miss. This is something that we have already discussed. Principle of natural justice, fair process, impartial process would be ensured. Like impartiality can only happen if there is independent judiciary. So these are the points that you can write if the question is that why do we need independent judiciary. You can write other points also, like to protect secularism, to protect democracy, you need to have independent judiciary. So independent judiciary is sine qua non. You can also mention about, see it is a part of basic structure. Or rather in conclusion you can use it if the question comes, that that's why Supreme Court has declared it as a part of basic structure of our constitution. Clear? Any doubt? Okay, then another very mundane kind of question. I know you must be knowing the answer of it, but please give me the answer. How is independence of judiciary protected? This is also something you must have studied. Give me quick answer. What are the provisions in our constitution or otherwise that ensures the independence of judiciary? Part 5, probably that's not a very good answer. It is Part 5 is the union government. In that chapter 4, there is a dedicated chapter, but you got to tell me the specific provision that is there to ensure there is independence of judiciary. So, yes, probably Manoj and Yogesh, combinedly I can take one point that you are saying that in chapter 4 or in part 5, there is detailed provision about judiciary. So, there is separation of power. There is separate organ of judiciary that is there. But still some specific points are needed to answer this question. Some other points that you can think of. One of the points we have just studied. No. Article 124 is probably not the right point. The right point is collegium system. The collegium system is there to protect independence of judiciary. Yes. As such, collegium system is nowhere mentioned in our constitution. I have shown you the article 124. Article 124 merely says that president will consult Supreme Court judges and High Court judges, as many of them as he thinks appropriate. But through the interpretation of that article, the Supreme Court has given birth to collegium system. Okay, but definitely collegium system is a reality, and the purpose of collegium system is to ensure independence of judiciary. So first is in terms of appointment. See, think in this systematic way. First, judges would be appointed. In case of appointment, we ensure independence through collegium system. The next would be when they are appointed, they have to work there. So there would always be a fear that if I do not give judgment in favor of the government, I may be removed. So to avoid that fear, there is security of tenure. The judges do not have to contest election every 5 years. Once you are a judge, you will remain in office if you are in high court till you are of 62 years of age. And in case you are in Supreme Court, you are going to be a judge till your age is 65 years. So there is security of tenure. Obviously, there is a procedure for removal, but that procedure is also very difficult. It requires a special majority in both houses. A special majority in both houses of parliament, and this procedure is so difficult that till today, even in 70 years, no judge has been removed using this procedure. There were various, like there was this case of Justice Dinakaran. In his case, what has happened, that he was accused of corruption. He has amassed a lot of wealth. So people came to know that, okay, this is the person who owns, like, it would not be a right analogy, but people, like, this was the accusation that was made against him, that he owns probably property in every nooks and corner of the state. He was Chief Justice of Karnataka. So, like, once this was also the incidents that people, all the advocates, etc., they simply did a gherav. They simply uh, made him in his own in the High Court itself. The advocates did not allow him to go outside. Okay, they wanted his resignation. They were forcing him to resign. Then the procedure against him started. Like it was like common belief among people. I'm not here to give any judgment that he was corrupt or not, but this was the common perception that probably the wealth that he has amassed, or he and his family member, immediate family member amassed, cannot come through fair means. The salary of judges is not sufficient to justify that wealth. Okay, still the process of his removal could not be completed in the parliament. Before that only he resigned from his office. Okay, so motion was passed, but this process was not completed. Before that only he resigned, and there are only one or two instances where such process has even been initiated. So this is very difficult. I mean, it would be naive to assume that in the 75 years of independence, including all the high courts and Supreme Court, there has been only two instances of corruption by the judges. So there is definite protection, security of tenure that is given. Okay, the expenditure of the judges, this is also something we have studied, is charged on consolidated fund of India. We have studied it part of the money bill, that any expenditure which is charged is going to be a part of the money bill. Okay, charged expenditure, we have also seen that it is an expenditure which is not voted upon in parliament. It has to be passed as it is by the Lok Sabha. Okay, then no personal criticism of judges' conduct. What is the article number? Yesterday only we have discussed it, that parliament cannot discuss, or state legislature cannot discuss the conduct of judges except when the motion for their removal is being discussed. Obviously, if you are removing someone, you will discuss about his conduct, but except that, their conduct cannot be discussed. This is article number 121. If you are not able to recall, go and revise the studies class notes. I'm just presuming that you are making notes. This is how, yes, right, Manoj, article number is 121. There was also another article which was saying that, which was other way around, that the judiciary will not interfere in the proceedings of the parliament. What was that article number? I will wait for your answer. And there is also power of contempt of court with judiciary. And this is like the power to punish for its contempt is with both High Court and Supreme Court. Yes, you are right, Manoj. That article is 122. So they have the power to punish for their contempt in case someone says something which is derogatory to the judiciary. Okay, in that case, they can punish for the contempt of the court. And you have the example. Can you recall any example? For example, Prashant Bhushan was found guilty of contempt of court. Yesterday, I was watching a reel. So in that reel, there was one judge of the High Court. Probably he's judge of Bhopal High Court. So he said that from where have you learned this way of argument? इस तरीके की वकालत कहाँ से सीखी है आपने? He was talking in Hindi. And then the advocate, the counsel, he said that, Lord, my lord, I have learnt it from you only. And the judge became very furious to say that don't take me lightly. This is a matter of contempt. So when you are accusing for no reason of all, you are doing anything which scandalizes, the word used is which scandalizes the authority of court. In that case, you can be penalized for contempt of court. So, and that's why you must have seen that, I mean, against the Supreme Court judgment, people are very careful. They, like, if government does anything, people can write anything on Twitter, Facebook, etc. But when Supreme Court gives any judgment, people treat it very carefully. So somehow, I mean, judiciary has been able to maintain, despite the whatever we have studied, that in the collegium system there is something wrong, there could be some instances of corruption, but despite that, by and large, judiciary has been able to maintain its credibility among people. Like in that book, India After Gandhi, Ramchandra Guha writes that judiciary commands a respect or a confidence among people which other two organs have largely lost. And when it comes to politicians, like large majority of Indians believe that probably honesty is something which is not found among them. But probably a large majority of Indians believe that among Supreme Court judges, at least, there are a lot many honest judges out there. Okay, so that's all that we have to cover. in this part. Now we shall move to next topic of our day, that is judicial review. Any doubt you may ask till now, if everything is everything okay, or you have any question? Okay, so let's see what is judicial review. We have used this word time and again, but sometimes it, sir, contempt of court is punishable, jail or fine, or both. There is a contempt of court act. Contempt of court is both. There are two kind of contempt of court. One is civil contempt, another is criminal contempt. In case of civil contempt, there is provision of fine. In case of criminal contempt, there could be fine or even imprisonment. Okay, or there could be both. But usually, judiciary has been using it very sparingly, because in a democracy, judiciary has been given. See, again, I will just very briefly discuss you the contempt of court also. See, the contempt of court also have the same problem as is with the parliamentary privileges. In case of contempt of court, you have scandalizes the authority of the court. You have said something against the Supreme Court, and then again, who is going to deliver judgment on that? The same Supreme Court. So there is also the violation of principle of natural justice here also, and it is also often considered as anti-democratic. It stifles criticism. See, there is one contempt of court which is civil contempt, that when Supreme Court has given any judgment or any court has given a judgment or order and you are willfully disobeying that order. Court has said it, the government court gave the order to the government that you release the particular person, and that person is not released. Government is saying that I will not release it. I mean, the judges will not go to the jail, na, and open the locker and say that this person is released. What judges will do? Judges will only pass an order. The government said that we are not going to follow it. So that is considered a civil contempt. See, that is okay. Court orders must be obeyed. Right or wrong, there is mechanism of appeal. If you are not happy with this, you can go to the High Court, you can go to the Supreme Court, you can go to file for the review petition. All those mechanisms are there. But whatever be the case, the order should be implemented. Otherwise, court authority is lost. And once court authority is lost, the whole democracy would be in disarray. We would become Bangladesh. So that's the one thing. But when someone is criticizing the court or criticizing the judgment, and if like the criminal contempt is there where you scandalizes the authority of court, so you do something, you say something that brings disrepute to the court, and that is criminal contempt. And this is something which stifles criticism, which is like the freedom of a speech and expression is taken away. This is a basic ingredient of democracy. So that's why if court exercise this contempt power very frequently, it is not good for any democracy. It is not respected. So that's the reason why it's like it has been a practice in UK that the court has probably for last 1 or 2 decades has not exercised any contempt power in UK. This was the data that was there in the newspaper. They have they have developed a convention that we are not going to exercise the contempt power. So similar is not the case in India. Very frequently in India, the contempt, because the Indian people are also not as civilized as that in UK. But still, by and large, judiciary maintains restraint. It does not proactively deals with contempt power. Okay, contempt cases. Next is, what is judicial review? So judicial review is simply when judiciary is reviewing the action of executive or legislature. Okay, in that is called judicial review. Okay, this is the power of the Supreme Court or High Courts to examine the constitutionality of any law or executive action. Judicial review is applicable to both executive action as well as legislative action, but by and large, when we are, mostly we deal with legislative action. And see, this is from where it is coming. This is coming from the fact that judiciary is the, this is in a way, judiciary is the final interpreter of constitution. So, since judiciary is the final interpreter of the constitution, it has to interpret the constitution. After that interpretation, he will have the right to say what is constitutional or non-constitutional. From there, the concept of judicial review is taking birth, or in a way you can say that the process of interpreting the constitution is what is known as judicial review. Okay. Next is, as such, explicitly judicial review word is nowhere mentioned in constitution. If nowhere explicitly in the constitution, if you do the control F judicial review, you will not find any match. But implicitly through various provision of constitution, we are getting this judicial review. So what are the sources? The first thing is that we have a written constitution. We have studied it in the very first lecture that written constitution means that constitution is supreme document. Since constitution is supreme, all other laws of the land has to have to abide by the constitution. And since judiciary is the interpreter of the constitution, then judiciary will see which law abides by the constitution and which law does not abide. And if a law does not abide, it would be declared null and void. So the very fact that we have a written constitution gives rise to the power of judicial review. The next is Article 13, which explicitly says, this is explicit about fundamental right. This is also something we have studied, that no law shall be violative of any provision of Part 3. And then Article 32 says that in case any of the fundamental right is violated, one can directly approach the Supreme Court, and Supreme Court has the power to issue writs. So Article 32 gives writ jurisdiction to Supreme Court, and Article 226 gives writ jurisdiction or power to issue writs to high courts. So these are the explicit provision, but these are the provisions for, like, one more question is there, that the writ jurisdiction of high court is broader than Supreme Court, because Supreme Court had only, this is something which is counterintuitive. Normally we feel that Supreme Court should have broader jurisdiction. It is supreme, like we have in case of Parliament. It has broader powers as compared to a state legislature, but that's not the case. In case of Supreme Court, the writ jurisdiction is only limited to cases involving fundamental rights, whereas high courts have writ jurisdiction for issues included in fundamental right and any other legal issues. So that's why writ jurisdiction of high court is broader than the writ jurisdiction of Supreme Court. And then Article 246, this is an article which mentions the division of power. That is, it has three lists. It mentions about three lists. So the very fact that we have federal system means there has to be a system of judicial review, because there is one government which has its defined jurisdiction, there is another government which has defined jurisdiction. If a government exceeds its power, there has to be someone to review this, if that the government are not exceeding their jurisdiction. So this federal system is also implicitly giving rise to the concept of judicial review. Okay, and suppose this is a direct question, you have to write more points, then you can write those other points also, like the basic structure doctrine. This says that if something is violative of basic structure, that can also be declared null and void. And this has also said that judicial review is part of basic structure. Judicial review is part of basic structure. So basic structure, as you must have understood by now, that you have to think of basic structure everywhere. Can I fit in? And in a lot many answers in polity, wherever the constitutional interpretation is involved, question is in secularism, basic structure. Question is on federalism, basic structure. Question is on judiciary, basic structure. So that's the importance, and invariably do remember that which judgment have given which basic structure. So if you mention the judgment also, you will probably have better impression on examiner. Is it clear? Next, we are going to see that this power of judicial review has given rise to a phenomena known as judicial activism. What is this judicial activism? As a judicial activism has also taken birth in USA, and you know, like globalization has linked the economic systems around the world. Similarly, even the political systems around the world are linked. Like whatever be the rights which are enjoyed by the people in the West, invariably that becomes the basis for wider interpretation of some of the rights in India. Even like the phenomena of judicial activism, this is something which was first witnessed in USA. The US Supreme Court over there, it started giving wider interpretation to the fundamental rights which are there. And then it was picked up by the other courts, including the courts in India. Okay, so judicial activism is as such. Yes, Yogesh, you are very right. You have answered at the core of the issue, that when legislative or executive action is being taken up by judiciary. But probably the concept is like something more basic. If I have to define it, what I would rather say, that see, normally, traditionally, the function of judiciary is to just interpret or see what is written in the constitution or in any statute and go by that. So when judiciary is just sticking to its traditional business, its work is to see what is written in the statute and interpret it and act accordingly, give judgment who is right and who is wrong. That is simple judicial action. But when judiciary is moving away from its traditional function and it is also interpreting the constitution in terms of its social implication, that is called judicial activism. So suppose I will just give you an example. Like the constitution is saying that no one shall be deprived of his life and liberty except procedure established by law. Now the traditional judiciary should have simply read the word like except procedure established by law. So in case there is a procedure which is established by law, then your life and liberty can be taken away. If there is no procedure, it cannot be taken away. Simple. But judiciary also started going to that. That's what if a law is arbitrary, irrational, illogical? What would be its implication? That implication is also being considered by judiciary, and then judiciary is saying that no, we will not go with procedure established by law, rather we will go with due process of law, because we are in the democracy. This is judicial activism. When judiciary is not being bound by merely the words written. Rather, the words written are being interpreted as per its implications. So, you can write down the definition of judicial activism. It's a judicial philosophy. It's a judicial philosophy which motivates judges to depart from the traditional precedents, which motivates judges to depart from the traditional precedent, to depart from the traditional precedent in favor of progressive, in favor of progressive and new social policies. So when they are departing from the traditional judgment, traditional interpretation, and they are interpreting something in the new social realities, when they are progressively interpreting the constitution, like when they are saying that third gender is the reality, they are progressively interpreting the constitution. Right to privacy is the part of fundamental right. This is called judicial activism. So, judicial activism is not merely limited to the fact that judiciary is doing something which is the part of which should have been done by the executive and legislature. That is something which is judicial overreach. So, judicial activism is when judiciary is giving a broad interpretation of the constitution. That is judicial activism. It is more broad than entering into the domain of executive and legislature. Sometimes in this process, judiciary will enter the domain of executive and legislature, and that we are calling as judicial overreach. Judicial overreach has slightly negative connotation, whereas judicial activism has positive connotation. When the word judicial activism is there, I mean, this is the common consensus among the legal luminaries that judicial activism is required. But probably judicial overreach is something that we should be avoiding. Okay, we shall talk of more about this, but first let's see what are the advantages that has come through judicial activism. The first advantage that has happened is there has been expansion of the meaning of rights. You have to write examples over here. You can write n number of examples. How right to life or how right to freedom of speech and expression has been uh, widely interpreted, like clean air, decent life, right to food, right to employment. All these have been declared as fundamental right by the Supreme Court. Next is courts are becoming more accessible. Like judicial activism has given right to a phenomena of public interest litigation or social action litigation. SALE, social action litigation. So now the judiciary, if certain people cannot reach the doors of the judiciary, judiciary is reaching to the doors of the people. It has democratized the judicial system as well. Like when it is more accessible, it is more democratic. Then it improved the government accountability. Now, if government is not doing its duty, it is being questioned. Can you give me some example? Like let's take the example, like the Supreme Court is asking the Delhi government about the pollution. There was a very funny statement given by one of the judges, and so this is something probably at the beginning of my lecture series. I have told you that in few days time we would have very frequent daily basis news about the pollution in Delhi. As a few years ago, one of the judges says that, see, my grandson has to wear mask in the home now. in Delhi. He looked like ninja. Okay. So he was so furious, the judge of the Supreme Court, because the government is not doing its duty. Accountability is now being asked. The questions are being asked by judiciary also from the executive and legislature. Now, one other thing is that judiciary is also doing certain things which is being to be done by legislature and executive. But here, when we are writing that what are the positives that had happened, we would use the word not entering into the domain. Rather, judiciary is filling the vacuum left by legislature and executive. Okay, slightly change the language. Judiciary is filling the vacuum left by legislature and executive. For example, the best example is like electoral reforms. This is something which has not been done by the legislature and executive. Why would someone reform himself? Yesterday only I was reading a book in which the author was saying that 99% of the people do not accept that they are wrong. Even if you are wrong, even if the whole world is saying, he has taken the example of various criminals, etc., who have been given sentences by the court, and that criminal, if in the interview, do not say that he has done anything wrong. So, obviously, the MPs will not say that they have done anything wrong. They will not say that criminalization of politics is wrong. They say that obviously the politician has to be having some muscle power. Then only you will be accepted as leader. He would say that I have used muscle power or I have used something for the good cause. Otherwise, like my religion, my region, my people, or whatever be the case, would not be protected. So, this electoral reforms can only be done through judicial action. Okay, or even like you can say mention about Visakha guideline, which became the basis for POS Act, Prevention of Sexual Harassment at Workplace Act. Okay, so this has like judicial activism has given rise to the phenomena of public interest litigation. One of the points that we had is public interest litigation, which is also known as social action litigation. Now you have to have the understanding, the clarity, what is this public interest litigation? Public interest litigation is one subset of judicial activism. It is not complete judicial activism. Okay, judicial activism is a broad term. Public interest litigation is a subset of it. And why we call it as public interest litigation? Because normally when you go to the court, court always asks you why you are in the court. What's your agenda? Or which is in legal terms called as what's your locus standi? What's your logic, rationale for standing in front of this court? So you will always say that, see, since that person has acquired my property forcibly, so that's why I am in the court. Because see, that person has committed a crime against me, or that person, we have a dispute between him and me, because my fundamental rights are violated. That's why I am in the court. So usually the aggrieved person approaches the court. That's the simple term. If your issue, you have to approach the court. You cannot say that, see, actually my cousin has is uh, his fundamental right is violated, but to protect his fundamental right, I am coming to the court. That is not allowed. If your cousin's fundamental right is violated, he should come to the court. Okay, but in case of public interest litigation, what happens that this principle of locus standi is diluted. Some public spirited person can approach the court in the larger public interest, even if his personal interest is not compromised. For example, I can be moved by the plight of the beggars on the street. And I can see that, see, their right to life or right to dignified life is compromised, or suppose they are being moved by the government is breaking their uh, what government is doing, government is taking bulldozer action against them. Those people might not be in a position to approach the Supreme Court to enforce their fundamental rights. So I, being a public spirited person, I can approach the Supreme Court on their behalf. So my personal home is protected. No bulldozer is being run on that. Still, if I am approaching the Supreme Court on their behalf and Supreme Court is allowing me to litigate in front of the court, that is called public interest litigation. Okay, so as such, it may or may not involve judicial activism. But since it is again a departure from traditional practice, it is considered as one subset of judicial activism. But obviously, the traditional practice which was followed by the court is being broken. And invariably, the public interest litigation uses the route of writ jurisdiction of Supreme Court, where one or another fundamental rights are to be enforced, when it is claimed that the fundamental rights of the people are being violated. So that's why obviously there is a lot of overlap between judicial activism and public interest litigation. Okay, so this is something which is the definition of public interest litigation: proceedings in which an individual or group seeks relief in the interest of the general public. It dilutes the concept of locus standi, and the first public interest litigation, like there is debate whether the Hossan Ara Khatun, few sources write that Hossan Ara Khatun versus Bihar case was the first public interest litigation. The few books or few sources write that Sunil Batra versus Delhi administration was the first case. These two cases are important to understand the holistically what the case was. Probably the judgment came in this case first, whereas the case was, this was the first case which was filed. So this was the case which was related to the plight. Both of the cases were related to the plight of prisoners only. Here the issue of under trials was involved. Even today also you can see that 75% of prisoners in our jail are under trials. Those who have not been yet convicted, many of them might not have committed the crime. There is just the accusation that they are a criminal. Okay. So in this case, the Supreme Court gave the judgment that right to a speedy trial is fundamental right, is part of right to life. Okay, so this satisfies the judicial activism. The Supreme Court has given wider interpretation to the fundamental right which is there. Okay, and then in this Sunil Batra was a Delhi administration case. Sunil Batra was the inmate in Tihar jail, and this is like this was a case which was taken because this person has written from Tihar jail a postcard, and based on the postcard, the Supreme Court has considered that postcard as a litigation. Later on, this practice of accepting postcard, because a lot when postcards started coming to the CGI, was discarded. But this was the case which was admitted by Supreme Court on the basis of a receiving a postcard in which he has said that the jail administration was not giving a human treatment. I mean, this is fact. We consider that those who are in jail are criminal and the criminal do not have any right. So here the Supreme Court says that there cannot be any inhuman treatment. No inhuman treatment of inmates. No inhuman or degrading treatment to inmates or prisoners. Okay, so now the case is that these are the cases where some public aspirated person on behalf of prisoners cannot approach the court. Someone else has to approve. There is another case which is famous case of PIL that involves the workers during the Asian Games in Delhi. So they were living, a lot many workers from different parts of the country have come to Delhi. They were working in the construction of the stadium and other infrastructure project when Asian Games were to be held in Delhi. So obviously they were not living in a humane condition. They were living in slums like condition. So and they were not being paid minimum wages either. So these people who are not even being paid minimum wages, how can they approach courts for enforcement of their rights? So someone else has to go to the court on behalf of these people to enforce their rights. So these are the, since invariably it involves some social action, some amount of social justice is involved, that's why the name social action litigation. Okay. Next is, obviously it was well intended, it was done with the purpose of making, so benefits of PIL would be invariably the same, the benefits of judicial activism. Okay, like, but you have to just take all the example which involves the PIL. Okay, the only difference, otherwise the benefit is same, that PIL has led to broader interpretation of various fundamental rights, it has made justice accessible, it has democratized the judicial process, all those good things have to done. It has led to various social reforms, it has made the government accountable, all those points are same. Okay, but obviously there has been some side effects of judicial activism or PIL that you can say. For example, first is it leads to violation of separation of power when judiciary enters into domain of executive or legislature. Can you give some example? Yes, judiciary being overburdened, that's another point. That is probably the second point. Overburdening of courts. Can you give me example where judiciary has entered into the domain of legislature and that is not good? For example, simply this NJSC case. To make a law or to do a constitution amendment is the domain of legislature. When judiciary is being overzealous, overactive and declaring such an amendment as unconstitutional, it is definitely an example of violation of separation of power. Or you can take various examples, for example, like in during COVID-19, like when there is an emergency to take action is the duty of executive. Now judiciary has started taking action, like whether oxygen cylinders are there or not, what you are doing, how people are suffering and all those things, whether you are running trains or not, why there is a lockdown. When there is a crisis on the ground, executive has to be busy in doing its own function. Then judiciary getting involved in addressing that crisis is an example of violation of separation of power. It has led to overburdening of courts also. During COVID-19, the number of pendency of cases rised within a year from 4 crore cases to currently we have 5 crore pending cases. 5 crore cases are pending, you are not dealing with your own matter and you are busy asking questions from the government what government is doing. And a lot many cases the suo motu action is taken. Oh, I am not saying that the judiciary should not do it, but this is the problem side effect with judicial activism. See, in general, I will have a good opinion of judicial activism. A lot of good has happened. But when I have right to criticism, I have to be critical. That's the point. It has also eroded the credibility of executive and legislature. For example, in 2G scam allocation case, 2G spectrum allocation case, Today we know that all the people who were accused of a scam, they have been set free. But the Supreme Court said that this policy of allocation of a spectrum on the first come first basis was unconstitutional. So it was a policy domain which was the domain of executive, and in that domain the Supreme Court entered and said the what kind of policy you can have and what kind of policy you cannot have. Obviously, the people lost faith in executive and legislature because of that. Again, it is also giving rise to judicial overreach. Judiciary is doing something which it should not be doing. For example, Judiciary gave an order that there should be no sale of liquor within 5 kilometer radius of national highway NH. Now, where liquor would be sold and where liquor would not be sold, that is not something to be decided by judiciary. You are encroaching into the domain of the state government and central government. Or when judiciary, there was also an order that in all the cinema halls, the national anthem would be played at the beginning of the movie. And judiciary often lacks the expertise. For example, it gave order that all the diesel vehicle of more than 2000 cc capacity, they were banned once in probably 2015. 2015 Supreme Court gave the order that the diesel vehicle with capacity more than 2000 cc in NCR would be banned. At that point of time, the Volkswagen India head, he has given this a statement that the exhaust of the vehicle from Volkswagen is purer than the air of Delhi, because he was claiming that the vehicles made by his were already at that point of time, Bharat 6 norms have not come, but he was saying that our vehicles are already deploying those technologies, because of which the exhaust that are coming from my vehicles, my SUVs vehicle, which are the high end premium vehicles, they are not polluting the air of Delhi. Rather, the Delhi air is already much more polluted than the exhaust of my vehicle. So clearly, the judges were lacking the expertise of this, how the vehicles are running, what are the technology involved, etc., or the pollution control measures, like banning of crackers. First, Supreme Court banned crackers. Then Supreme Court says that okay, green crackers are allowed. No studies have been done. I mean, how much impact is there of due to crackers? How much impact is there? I mean, this year Diwali is delayed, so this year the pollution has reached Delhi before Diwali. Had Diwali been on time, I mean, had Diwali been a 15 days earlier, probably we would have attributed pollution to Diwali, the crackers, etc. So definitely the technical expertise required to deal these issues are not found with the judges. And some people with vested interest have also misused time and again. For example, this was the case uh, of Noida extension. This was the uh, real estate project. So there was land acquisition done by the UP government for Noida extension. There was land acquisition to be done by the UP government for Noida extension. People went against it having a PIL in the Supreme Court, and the Supreme Court uh, nullified this land acquisition. Later on, it was known that PIL was actually filed by the group of real estate developer. So these real estate developer were worried that in case this Noida extension project is implemented, the real estate projects which are being developed by them, they would lost value. So they filed PIL. I mean, in pretext of public interest, the private interest was being protected. Okay, so a lot many times the people with vested interest have also filed PIL to public interest to protect their private interest. So there are these side effects also, but in general we would say that this is a good thing only. Your conclusion should not be that we should stop PIL etc. Because in defense of the PIL, only 1.8% cases in Supreme Court are under writ jurisdiction. The Supreme Court is overburdened. In tomorrow's class, we shall see uh, the reasons for the delayed justice in judiciary. But the maximum cases which are pending in courts are under its appellate jurisdiction. It is not the writ jurisdiction which has overburdened the higher judiciary. Only 1.8% cases are under writ jurisdiction. But still, why do we see there is increasing number of PILs? The reason is because, first of all, because there has been dilution of locus standi, anyone can reach the court. So a lot many people are reaching. Why people are also reaching? Because the other avenues like bureaucracy, the legislative, there is inaction. You are not getting action. Like here you can take the example of electoral reforms. The legislative action is not happening, then what option do people have? Here you can take the example of environmental problem. When bureaucracy is not acting. In fact, see what has happened actually, uh, that if you read the local newspaper etc., you can come across various sub PIL. For example, roads are not constructed. Now people are approaching high courts that in my vicinity drain is flowing, my fundamental right is violated, please give order. And since it is working, the issue is also that judiciary is accepting, judiciary is willing to solve the problem of the people. Since judiciary is willing to solve the problem of the people, people are approaching, and under the order of judiciary, the problems are also getting solved. This is something that you have to write if a question is asked, that it is both way. First, government is not acting, then people have to approach judiciary, and second, the judiciary is overzealous. There are overzealous judges also. I mean, in the courts, there are certain judges which have came to be known as green judges, who are very often dealing with the environment related matters. There are judges who are famous for acting on social on PILs. Okay, there is a judge in Rajasthan High Court which has given around more than 10 judgments against the Rajasthan Public Service Commission. Whenever like any question is wrong, people appeal under that bench only. They try that our case should be heard by that bench, and that bench sides with the students. I'm not saying whether it is right or wrong, but since this is something which has given rise to increasing number of cases. Then the fundamental rights interpretation have increased also. Like Supreme Court has itself given broader interpretation. Now there are a lot many fundamental rights. So people are using writ petition to enforce those of their rights as well. And now judiciary is also being focused on social justice, and these cases get media attention. So that's why more and more advocates are also filing the, like this is something which is good for both judges as well as advocates, but this gives a lot of publicity to advocates. So that's why advocates are also interested in filing PILs. Even if they are not being paid any fee, they are spending their time because this makes them famous. And once you are famous, once you win a PIL, then you can charge more fee. Then more cases will come to you. It can increase your revenue. And now people are also being more legally aware. Since people are more aware of their rights, their duties, the government's duties, government's responsibilities, people are also approaching court more frequently. So these factors all together See, when you write answer to this question, each of these point should be given some example. Like even dilution of locus standi, you can give the example of any of the PIL that you can say, for example, Sunil Batra case. Okay, bureaucratic unresponsibleness, we have given example, judicial activism. So in all the cases here, you can give the example of say Puttaswamy case. So because of the Puttaswamy case, the right to privacy has come. So give some example of cases as well which has given rise to, I mean, examples are must. This is what I am trying to convey. You must have examples for all the points. With examples only you can get exceptional marks. That example will only distinguish your answer from the answers of others. Okay, is it clear? If you have any doubt, please let me know. Otherwise, we are stopping here only today's class. In tomorrow's class, we are going to deal with judicial pendency and the issue of alternate dispute resolution, the Lok Adalat, the arbitration tribunal. These are the issues that we are going to cover in tomorrow's class. Okay. So since there is no doubt, everything has been understood by you, crystal clear. We shall meet again tomorrow 2 p.m. Have a nice day.